Hello everyone. Welcome back to our channel, Immigration Canada. Canada Immigration 2026. How IRCC can lawfully refuse your application despite full eligibility. Please like, subscribe, and hit the bell for future videos. Why this topic matters to every immigration applicant. This topic matters because it directly affects the future of anyone who has applied for a Canadian study permit, work permit, visitor visa, or permanent residence, as well as those planning to apply in the coming years. For many applicants, immigration is not a casual decision. It involves substantial financial investment, long-term planning, career transitions, and personal sacrifices. Yet despite the seriousness of these decisions, countless people move forward with a critical misunderstanding about how Canada's immigration system actually works. They believe that meeting all the requirements guarantees approval. That belief has quietly led to refusals, lost savings, broken timelines, and deep frustration. Understanding the real mechanics of immigration decision-making is no longer optional. It is essential for anyone who wants to protect their future and approach the process strategically. The checklist belief that creates false confidence. For decades, Canadian immigration has been described as a structured and predictable process. Applicants are encouraged to review eligibility criteria, gather required documents, submit complete forms, pay the necessary fees, and wait for a decision. This checklist-based explanation feels logical and reassuring. It gives applicants the sense that the process is objective and outcome-driven, where effort and compliance naturally lead to approval. As a result, many people commit to life-altering plans such as enrolling in international education, leaving stable employment, or relocating families based on the belief that careful preparation guarantees success. However, this understanding is incomplete. While the checklist ensures that an application is eligible for review, it does not determine the final outcome. The real decision-making process is far more nuanced. The legal authority behind immigration decisions. Under Canadian immigration law, officers are not required to approve an application simply because the applicant meets the minimum eligibility criteria. Their legal responsibility goes beyond confirming that documents are present or forms are complete. Officers are mandated to assess whether they are satisfied that the applicant meets the intent, credibility, and compliance expectations set out in the law. Eligibility is only the entry point into the process, not the conclusion. Officers are empowered to evaluate the overall context of an application, including whether the applicant's plans make sense, whether their background supports their stated goals, and whether approving the application aligns with Canada's immigration objectives. This discretionary authority is not accidental, it is a core feature of the system. Discretion as the core of the system. Many applicants assume that discretion is used only in exceptional cases. In reality, discretion is the foundation of immigration decision-making. Officers are trained to weigh evidence, assess consistency, and identify potential risks. They examine whether an applicant's personal history aligns with their future plans, whether financial resources are realistic given the stated purpose, and whether the overall story holds together logically. Two applicants may submit similar documents and meet identical eligibility criteria, yet receive different decisions because one application presents a coherent and believable narrative while the other leaves questions unanswered. This is not inconsistency or bias. It is discretionary judgment functioning exactly as designed. Complete applications versus convincing applications. A critical mistake many applicants make is assuming that a complete application is automatically a strong one. A complete application includes all required documents, submitted correctly and on time. A convincing application goes further by explaining intent, addressing potential doubts, and presenting a logical progression from past experience to future plans. Many refusals occur on applications that are technically flawless but strategically weak. There are no missing documents or procedural errors. Instead, the refusal is based on the officer's conclusion that something does not fully make sense. In immigration, completeness allows your file to be reviewed, but credibility determines whether it is approved. Immigration decisions are built on trust. Immigration decisions are not purely administrative. They are analytical and judgment-based. Officers are trained to identify both obvious and subtle risk indicators. A study plan may meet academic requirements but fail to demonstrate realistic career outcomes. A work permit may satisfy eligibility rules while raising concerns about the genuineness of the job offer. A visitor visa may show sufficient funds but lack convincing evidence of temporary intent. Even permanent residence applications, which follow structured programs, are subject to credibility assessments. Officers are not simply reviewing documents, they are deciding whether they believe the applicant's story. Trust and belief play a central role in every decision. The burden of proof always rests with the applicant. One of the most important principles in Canadian immigration is that the burden of proof rests entirely with the applicant. Immigration, Refugees and Citizenship Canada does not have to prove that an applicant is a risk. The applicant must prove that they are not. If an officer has doubts whether about intent, plans, or circumstances, the application can be refused without further inquiry. Officers are not required to request additional documents or offer opportunities for clarification. This surprises many applicants who expect dialogue or follow-up. In reality, silence often means that the decision has already been made. Why refusal letters feel incomplete? Applicants frequently express frustration at how brief and generic refusal letters appear. While the internal reasoning behind a decision may be detailed, refusal letters often rely on standardized language that meets legal requirements. Phrases such as "based on the information provided" or "I am not satisfied" are considered sufficient explanations. The system prioritizes efficiency over individualized feedback. Although access to officer notes has improved transparency in some cases, applicants should not expect detailed guidance in refusal letters. Understanding this limitation is essential for managing expectations and planning effective applications. Timing and policy climate matter more than you think. Timing plays a significant role in immigration outcomes. Applications submitted during periods of policy tightening, increased scrutiny, or political pressure often face higher refusal rates. This is particularly relevant in 2025 and 2026, as Canada has publicly acknowledged efforts to recalibrate temporary immigration. Officers are operating under stricter risk frameworks, and approval standards are evolving. An application that may have succeeded a few years ago could face challenges today, even if it appears strong on paper. Immigration decisions are influenced by broader economic, social, and political contexts. The myth of guaranteed explanations. Many applicants believe they are entitled to explain themselves if an officer has concerns. In most temporary resident applications, this is not the case. Procedural fairness letters are issued only in limited circumstances, typically involving serious allegations such as misrepresentation. In cases where an officer is simply not satisfied, applications can be refused without warning. This makes proactive clarity and persuasive explanation in the initial submission critically important. Waiting to explain later is often not an option. A common scenario that reveals the difference. Consider two international students applying from the same country, selecting similar programs, and submitting comparable financial documents. One application clearly explains how the chosen program fits into a realistic career path, supported by prior education and work experience. The other relies on generic language and template-style explanations. Both meet the eligibility criteria. Only one convinces the officer. The difference is not documentation or qualifications, but credibility. This scenario is repeated across all immigration categories and highlights the importance of narrative clarity. Appeals and judicial review, understanding the limits. When applications are refused, many people turn to appeals or judicial review expecting a fresh assessment. However, judicial review does not reconsider the merits of an application. It examines only whether the decision was reasonable and lawful. If the officer's reasoning falls within a reasonable range, even if it feels harsh, the refusal will stand. This is why reapplications often fail when applicants repeat the same approach. The issue was not missing documents, but a failure to persuade. The hidden rule that shapes outcomes. The rule most applicants never hear is that IRCC does not evaluate applications in isolation. Applications are assessed within broader risk and trend frameworks. Officers consider patterns across thousands of cases. When certain pathways become overused, scrutiny increases. When abuse is suspected in specific regions, caution intensifies. When programs face political pressure, decision-making tightens. These dynamics are not published in application guides, yet they influence outcomes every day. Understanding this reality changes how successful applicants prepare their files. Did IRCC refuse your application? What to do next? Receiving a refusal from Immigration, Refugees and Citizenship Canada can be frustrating, confusing, and emotionally draining. After months of preparation, document collection, and waiting, a simple rejection notice, often with minimal explanation, can leave applicants unsure of how to proceed. However, a refusal is not the end of the road. Canada's immigration system provides multiple remedies, appeals, and corrective pathways depending on the nature of your case. The key is understanding why your application was refused and choosing the right strategy to move forward. This video walks you through every option available after an IRCC refusal and helps you determine the most effective next step. Understanding an IRCC refusal. When IRCC refuses an immigration application, whether for a visitor visa, temporary residence, or permanent residence, you will typically receive a written decision. This may arrive as a physical letter or a message through your online IRCC account. In most cases, the refusal notice confirms the decision but offers very little insight into the reasoning behind it. This lack of detail can make it difficult to assess whether the refusal was justified or the result of an error, oversight, or misunderstanding. Before taking any action, your first priority should be uncovering the exact reasons behind the refusal. Step 1. Obtain a Global Case Management System note. One of the most powerful tools available after a refusal is the Global Case Management System note. GCMS is the internal system used by IRCC and the Canada Border Services Agency to assess and process immigration applications. What GCMS notes reveal? GCMS notes provide a detailed behind-the-scenes view of your application, including application type, submission date, and processing status. Notes written by the immigration officer reviewing your file. Internal correspondence and decision-making comments. Documents reviewed and third-party submissions. Clear explanations outlining why your application was refused. This information is critical in determining whether your application was refused fairly or in error. How to request GCMS notes. To obtain GCMS notes, you must submit an Access to Information and Privacy, a TIP request, which carries a $5 processing fee. Only the following individuals can submit a TIP requests directly. Canadian citizens. Canadian permanent residents. Individuals physically residing in Canada. Applicants outside Canada must use an eligible representative who meets one of the above criteria and must also submit a signed consent for an Access to Information and Personal Information request, IMM 5744 form. IRCC is legally required to respond within 30 days, although extensions are possible. In practice, receiving GCMS notes can take several weeks or even months. Importantly, your application must have passed the R10 completeness check, which confirms all required documents were submitted, before GCMS notes can be issued. Step 2. Submitting a reconsideration request. Immigration officers are highly trained professionals, but errors can occur. If you strongly believe your application was refused due to a factual error, misinterpretation, or oversight, you may submit a reconsideration request. When a reconsideration request makes sense. A reconsideration request may be appropriate if you are confident that you met all eligibility requirements, submitted a complete and accurate application, provided correct forms and supporting documents, demonstrated sufficient financial capacity, completed biometrics and police checks where required, clearly established intent to leave Canada when applicable, did not misrepresent any information, were admissible under Canadian immigration law. How to prepare a strong reconsideration request. A persuasive RR package should include your GCMS notes, the original application and supporting documents, the refusal letter, a well-drafted reconsideration letter. Your reconsideration letter should clearly identify the specific errors or misunderstandings, provide factual and legal counterarguments, clarify ambiguous points in your application, include new, relevant, and credible documentation if necessary, maintain a professional, respectful, and persuasive tone. Referencing immigration policies or relevant case law can significantly strengthen your request. Reconsideration requests can be submitted via IRCC's web form or email, if specified in the refusal letter. While there is no formal deadline or fee, submitting your request promptly, ideally within 30 days, is strongly recommended. Step 3. Filing a notice of appeal. In limited situations, you may have the right to file a notice of appeal with the Immigration Appeal Division of the Immigration and Refugee Board of Canada. Situations where an appeal is allowed. You may appeal only if a family sponsorship application was refused. A removal order has been issued. IRCC determined you failed to meet permanent residency obligations. Temporary residence and most permanent residence refusals are not appealable. Grounds for an appeal. Appeals may be filed if there was an error of law or fact. Principles of natural justice were violated. Humanitarian and compassionate grounds justify relief. Strict deadlines apply, and failure to comply will result in dismissal. Inadmissibility limitations. Appeals are not permitted if inadmissibility was based on serious criminal convictions, crimes punishable by 10+ years under Canadian law, organized crime involvement, security threats, human rights violations. If an appeal proceeds, a hearing will be scheduled where evidence and witnesses may be presented. A decision may be issued immediately or within 60 days. Successful appeals result in reinstated sponsorship processing, cancellation of removal orders, restoration of permanent resident status. Step 4. Applying for leave and judicial review. If an appeal is not available, you may challenge the refusal through judicial review under the Immigration and Refugee Protection Act. Judicial review does not approve your application directly. Instead, the federal court evaluates whether IRCC's decision was reasonable, lawful, and procedurally fair. Stage 1. Applying for leave. Before judicial review, you must obtain permission from the federal court. Deadlines are strict. Matters inside Canada, 60 days. Matters outside Canada, 15 days. You must submit an applicant's record containing your complete application. Legal arguments. Supporting case law. If leave is granted, the case proceeds to judicial review. Stage 2. Judicial review hearing. Hearings are typically scheduled within 30 to 90 days. A judge will review all evidence and legal arguments. Decisions may take 1 to 6 months. If successful, your application is sent back to IRCC for reassessment by a different officer. Judicial review can take over a year and may involve substantial legal costs beyond the $50 court filing fee. Step 5. Submitting a new application. In many cases, the most practical option is simply to apply again, provided your refusal letter does not prohibit reapplication. This route is especially suitable if the refusal was justified. There was no legal or factual error. Your circumstances have improved. Before reapplying, ensure the issues that led to refusal are fully resolved. GCMS notes are invaluable here, as submitting the same information again is unlikely to produce a different outcome. Strengthen your application with updated documentation, such as improved financial evidence, clearer employment records, or stronger ties to your home country. Including a letter of explanation can significantly enhance clarity by addressing concerns directly and providing context not captured in standard forms. Apply promptly after resolving deficiencies, as immigration rules and eligibility criteria may change. Final thoughts. An IRCC refusal is not a dead end, it is a turning point. With the right information, careful analysis, and a strategic response, many applicants successfully overcome refusals and move forward. Whether you choose to request reconsideration, appeal, pursue judicial review, reapply, or seek legal counsel, informed action is your strongest ally. Stay proactive, stay precise, and approach the next step with confidence and clarity. Share your thoughts in the comments below. Thanks for watching. See you in the next one. Take care.